What are the barriers to a patent grant?
So there are legal barriers. I kind of talked about some of them. So some of these I'm going to go through, but there's a few in here I didn't talk about. One is non-patentable subject matter. You cannot get a patent on a law of nature. You cannot get a patent on a natural phenomena. You cannot get a patent on a mathematical algorithm. Although if the algorithm causes some, other invention, then you can. But in general, you can't have an algorithm, an equation, and get a patent on it. And you can't get a patent on abstract ideas. They have to be tangible. So I already talked about this one, which is the invention has already been disclosed somewhere else, prior art. We talked about that. It has to be new, or you fail to file within the grace period. And we talked about that. Inventorship. This is a really important one. So the failure to name all the correct inventors can invalidate your patent. So what does that mean? If you name too many, because maybe you have a business partner and you include, I've seen at big companies where the boss is always named on the patent. Or you add your spouse on the patent because you talk to them about it a bunch. But what has to be determined before a patent application is filed is who are the true inventors. And we do that by looking at the claims, and we do it again before grants. And every inventor should be able to point and say, yes, I was the one that said it should be red. And another inventor said, yes. And I also said it should have 4 legs on the table. So inventorship is very important. The biggest key when it comes to inventorship is when a patent is litigated. So that sounds like, well, that would never happen to you. But when a patent is questioned for validity, think about it. It goes to a standard court, a standard judge, and a bunch of jury who are picked. None of them know even what I just taught you, right? The judge, unless they've happened to have had some patent cases, they don't know. And the jury certainly won't know, because if somebody says, I'm an attorney or I'm an engineer, they're not going to get on the jury, right? So if you think about it, for somebody, an opponent in a litigation to show that inventorship is wrong, well, a judge can understand that. They might not understand the technical details, but they can understand when you say, well, you know what, they had this guy on here and he wasn't even in the same country and he didn't have anything to do with it. I take inventorship very seriously. And I always, if it's one inventor, it's no problem, right? If the person says, I did this all on my own, but I always ask the questions. We always want to be thinking about it. So even if you are creating a patent, if you have an invention that you believe is patentable, we still, if you have colleagues or friends or anyone else that should be named, we want to get the inventorship right. You don't lose any rights. You're still the inventor, but there might be 3 of you, not just one.